All right, good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I will let you know if I've determined probable cause from the police reports I read this morning, and then we will also talk about release conditions. Today is not your trial date. It's not an adversarial hearing, and so because of that, I encourage you to speak with your attorney before speaking on the record. Everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the attorneys from the Public Defender's Office, in the courtroom with me, I have Mr. Brian Reedy. Over at the main jail, I believe Mr. Hector Romero. And these attorneys are available to you. Those of you who are at the other facilities, they're available to you by phone. For those of you who are represented by private counsel, your attorney will come to the courtroom to address your case. If your attorney is not here and you know the name of your attorney, and you can let us know, and I will try and make a phone call. But please don't tell us that you have private counsel if you or your family did not retain that attorney for this recent arrest. Because an attorney represented you in the past, or maybe they're representing you on a pending matter, does not automatically mean that they're representing you on a new case. Also in the courtroom with me, I have the attorney from the State Attorney's Office, Mr. Eric Linder. And we also have representatives from confinement status, pretrial supervision, the clerk of courts. All these persons are here to help with the morning's hearing. They can provide additional information if needed, and anything else that is necessary for this morning's hearing. After today, your case will be assigned to a specific division judge, and then moving forward, any pretrial motions that you may have, or if you end up going to trial, will be heard by that judge. Some of you may see me again for 30-day motions, or per the administrative order here in the 17th Circuit, you may see me for a second look at your bond status, but aside from that, everything else will be handled by your division judge. For some of you this morning, if you're charged with misdemeanor matters or municipal ordinance violations, you may be able to resolve those cases here at first appearance, but that's also going to be dependent on what's going on with you personally. Otherwise, those of you who are facing felony charges, violation of probation, where the judge has already signed a no bond warrant, those cannot be changed at first appearance. You have to go before your division judge to handle those matters. All right? Okay, so, Mr. Reedy, you know Mr. Brian? Do you have, is there anyone from the jail that they want us to call out of turn?
Yes, Your Honor, we have two. They're both on page 10 of the court's docket.
Okay,
The first would be Mr. Jackson.
And the second one, Judge, is Mr. Earl Heath.
He's two cases further down the list.
Heath?
Heath, yes, ma'am.
Okay,
And Mr. Jackson is approaching, Judge.
all right, and, there's another one, Heath. Okay. And also, just so we address those now, we have some persons who have signed in, and depending on where you are your person is on the docket. So, Mr. Romero, on page 18, there's a Kelton Hardwick. Is he in the room?
You got it.
Mr. Hardwick?
Yes. Is he in the room?
Yes, he is. Judge.
All right. And then there's someone else on page 15, Ruben Chavez.
He is here, yes.
All right, thank you. All right, so James Jackson,
Yes, ma'am?
Mr. James Michael Jackson, you're before the court on two charges of resisting officer without violence. And I find probable cause.
Judge, after speaking with Mr. Jackson, he wishes to resolve this matter today.
Okay,
Offer be time served on each count.
okay.
He wishes to accept the state's offer, Judge.
All right, Mr. Jackson, you understand that you are resolving these matters before the state has formally filed the charges against you? That there will be no more investigation after this? You understand that?
Yes, ma'am.
Okay. All right, so please raise your right hand.
Right.
Do you swear or affirm to tell the truth?
Yes, sir. Yes, ma'am.
Okay, you can put your hand down. And Mr. Jackson, do you understand the offer that has been extended to you to resolve your case?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am. I'm too big for that.
All right, are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
Nope.
Do you
I think I
understand?
delegated with him enough.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
I've been Baker acted one time, and yes, ma'am.
Is there anything about that illness today that would prevent you from making a decision in regards to this case?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am. I was born at Jackson Memorial.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence as to both charges, adjudication, and time served. Good luck, sir. Earl Heath.
He's approaching, Judge. You see me?
All right, Mr. Heath, you're before the court this morning on one charge of trespassing. The other charge is a municipal ordinance violation, and I find probable cause.
Judge, and speaking Mr. Heath, he wishes to resolve this matter today.
On count one, Your Honor, the offer be adjudication, time served.
He wishes to accept the state's offer, Judge.
All right, Mr. Heath, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you today?
Yes, Your Honor.
Is anyone forcing you to resolve your case? Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
I do understand.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that today that would prevent you from making a decision? And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am. I do know.
All right, what plea do you wish to enter at this time, guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication and time served. Good luck. All right, on page 4, we have sign in for Adasa Kushni on page 4.
Ms. Cushing is here, Judge. She has private counsel.
Yes.
Morning, Judge John Hager on her behalf.
Good morning, Mr. Hager. Ms. Kushni is before the court this morning. Charge 1 is battery on a person 65 years of age or older. And number 2 is neglect elderly or disabled adults with great harm. I find probable cause for those charges.
Judge, I'm just asking for a reasonable bond to be set on count 1 in the amount of $2,500. Also, on count 2, it says that there's a level 2 pretrial release with GPS. She's a resident of Broward County, ties to the community, doesn't work at the facility any longer. We're asking if that condition can be deleted. She has no prior history. There's no reason for a GPS monitor.
Where are you getting that from?
I'm looking here.
It's on the warrant.
Oh, on the warrant, okay.
She doesn't work at the facility any longer. She has no prior history and no contact with the victim. So we're asking if we could delete that condition and have count 1, $2,500 bond.
Oh, there's also another condition of surrendering her passport.
That's not an issue.
Okay,
Your Honor,
yes,
it is true, I do not see any criminal history for Ms. Cushney. That being said, I am concerned this is an extreme level of violence against this alleged victim, and there appears to be strong evidence supporting the allegations, specifically video camera surveillance recordings that were taken showing the violence committed against the 97-year-old victim. Your Honor, I'm going to be requesting a $15,000 bond on count one. I'm also going to be asking that the court keep the special release conditions that Judge Siegel set in place. I'm also going to be asking for additional release conditions, obviously no victim contact, but also until further order of the court that Ms. Cushney may not work in any capacity providing any type of caregiver status to any elderly or disabled adults.
Judge, I can understand and appreciate where the prosecutor's coming from. However, $15,000 bond is tantamount to no bond for her, as she cannot afford that on count one. As well as count two, this victim lives at a facility. That's where she lives, and that's where she resides, and that's where she was taken care of. She's 97 years old. There's no reason to have a GPS monitor because she's not going to that facility. You can place a no contact that she can't have contact with the victim, but this victim is not going to be seen out and about in the community where she's going to have contact with her. So we're asking that that GPS monitor be deleted from count two condition.
Your Honor, while I hope the court will order that she's not to work in any type of caregiver capacity, and I would hope that she would follow any court order, a GPS monitor would confirm that she is not going to any type facility. Your Honor, and I know the court's familiar with the affidavit, and I only bring this up for record purposes. Just the amount of times that she allegedly struck this victim, that this victim suffered a broken femur and received absolutely no care from Ms. Cushney, that it was not even reported to anyone so that she could get the appropriate treatment for her broken femur, it is a cause for great concern.
Judge, I believe that's to be determined at a later time at trial. We're here to ask for a bond. This is a woman who is in a facility that's not leaving the facility. She's 97 years old. I don't think having a GPS would do anything for her. I mean, I think it's more restrictive to have that than giving her a bond where she could be on pretrial services, where she would have to say where she's working, what she's doing, and advise them by written reports. I think having a GPS monitor is not warranted, given the lack of history that she has. And we're asking that you remove that condition on count two.
so at this time, as to charge one, I am going to impose a $15,000 bond and order no victim contact, no return to that location. I also, an order that she, Ms. Cushney, not work in any capacity where she's a caregiver or taking care of any adults. And she must surrender her passport. I will delete the pretrial supervision at this time, but everything else will remain in place.
Thank you.
Okay? Right, if you'll just write an order that says the condition of the GPS is deleted.
Thank you, Judge.
All right,
Have a good day.
Your Honor, North Broward has a request for someone to be taken out of turn.
is it extremely urgent? Do you know, Ms. Aridi?
Yes, on page 13, it's Mr. Gene Doagene.
Oh, this is from yesterday.
Yes, that's correct.
yesterday.
Does he need a Creole interpreter?
Your Honor,
Yes.
also just to let you know, Mr. Dogene was referred to Judge Leonard yesterday.
Thank you.
I would have no problem with that, Judge.
All right, so Mr. Dojin is before the court on a trespassing charge. And based on the allegations, I do find probable cause. And based on the referral to Judge Lerner Wren's division, I will sign an order to transfer the matter to Judge Lerner Wren. All right? So Mr. Dojin, you'll see Judge Lerner Wren shortly. They've, do we need to send an email to
No,
their
I'll let,
division?
I'll let her GA know that we just.
Okay.
let him go.
All right, thank you. All right, on page 18, Kelton Hardwick. Good morning, Mr. Bellis.
How are you?
I am well.
Good, thank you.
Mr. Hardwick, here's your private attorney, Mr. Bellis.
And, Your Honor,
Yes,
if I could be heard before the court makes a finding,
okay.
I am assume on your findings, well, I won't assume, does it say aggravated assault?
I have aggravated assault with a deadly weapon without intent to kill.
The case was filed as an aggravated battery. If you look at the booking, it actually has that
And
one
I have the
comment.
capias that says aggravated battery with a deadly weapon.
Understood. I've been presented the probable cause affidavit, Judge.
I'm sorry, what was that?
I've been presented with the probable
Okay.
cause affidavit, and I looked
Okay.
online this morning, it mentioned aggravated assault, and then below it, it said aggravated battery.
It doesn't have a case number. You gotta put the roll.
Unfortunately, oftentimes, the wording don't translate well on these determination forms.
I just want to make sure when you set a reasonable bond, which the state is not objecting to, that the jail gets it right, you know, on the count. that-
They will, because they have it on the capias. All right, so I find probable cause, as presented on the capias, the aggravated battery with a deadly weapon, and I'll hear from the parties in regards to bond.
Your Honor, I spoke to counsel. We both spoke. We couldn't agree to a bond, but I don't think we're really far off. I was
Okay.
requesting a $10,000 bond.
Yes?
Your Honor, this is based on the level of violence alleged. I would note, as far as history, Mr. Hardwick has one prior. It is dated from the mid-'90s. It was a child abuse.
I believe that was a misdemeanor, that's my understanding.
Okay.
He self-surrendered, Judge. The alleged victim's girlfriend is my client's child's mother. It's his position the alleged victim is very abusive. She
Honor,
contacted
I'm gonna
him.
object to
I'm not trying to
this.
litigate the case. I
But
just want
there-
you to know, it's our position there was no firearm. As an officer of the court, the alleged victim reached out to me yesterday. I didn't have time to present him an affidavit. The case is filed. He wants the case dropped. He doesn't want to participate. He's not in fear of Mr. Hardwick, and I'm going to get the appropriate paperwork. I didn't have it this morning, but as an officer of the court, that's what he told me. My client's a hardworking man. It's his position there was no gun. I'm asking you if you would set a $5,000 bond. I don't think that's unreasonable, and he did self-surrender.
State?
He said he couldn't be here, but at the appropriate time, he said he would. He had to work.
Okay.
And I offered to call him, but I know the prosecutor's busy, and there's no way that they could verify that who I'm getting on the phone is the alleged victim. But
And it's not only that, Your Honor. We have a process. Whenever there's a waiver,
I
then you should go.
understand. All right. All right, so at this time, I am going to impose a $7,500 bond and no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. And this no contact order, sir, is in place until that order is lifted by a judge. Do you understand that?
Mr. Hardwick, did you hear Her Honor?
Oh, just push the button for the,
Yes, I understand.
all right. All right, thank you, Counselor.
Thank you, Your Honor.
You're welcome.
Good day.
You too.
Yes, sir.
Okay, on page 15, Ruben Chavez.
He's approaching, Judge.
All right, Mr. Chavez is before the court this morning. The charge is sexual battery. 18 years, the victim is older than 18 years of age. between 12 and 12 years less than 18. Okay. All right, so I find probable cause. And I'll hear from the parties at this time.
Your Honor, the state is going to be requesting a $150,000 bond, no victim contact, pretrial release of the GPS monitor, noting that there is DNA evidence in this matter. I would also note Mr. Chavez's criminal history, 2015 possession of hydromorphone. He was sentenced to just under 27 months in Florida State Prison. He was released from state prison July 10th of 2017. Additionally, he has a prior conviction in 1996 for trafficking cocaine over 400 grams, conspiracy to traffic cocaine over 400 grams, and possession of cocaine, and he was sentenced to 15 years in state prison in 1998.
Mr. Romero?
Judge, from what Mr. Chavez advised me, he's not gonna be able to afford the $150,000 which the state has recommended. And my understanding is, I believe the date of incident is well over, over 20 years. Right now, Mr. Chavez is working, he works for a subcontractor, restoring homes. He gets paid annually anywhere from about $20,000 to $30,000 a year. My understanding is he's been living in our community for well over 20 years. He lives right now with his girlfriend in Boca, and that's the person that he's gonna be relying on to help post his monetary bond. He appreciates that she is here for support. My understanding is I believe she works customer service for DirecTV, so I don't think her financial resources can come up with what the state has asked for $150,000. Now, Mr. Chavez advised me he has no objection as far as special condition being supervised by pretrial, but he just can't afford the $150,000. Judge, we're asking anywhere around like $10,000 to about $20,000 on Mr. Chavez's behalf.
All right, good morning, ma'am. Is there something you wanted to say?
He's a really good man. He's been doing so well. He's been working hard, and I can't afford that bond. If we could just, he's doing so great.
All right, we have very serious allegations here at this time, and the court, I have to take all of that into consideration in setting a bond. And so, based on the allegations, there are allegations of drugs and sexual battery. And so I have to take the allegations that are presented to me, and they're very serious. And so at this time, I find probable cause. I am going to impose that $150,000 bond. And no victim contact, which means no phone calls, no text messages, no social media, no third party, no person calling on your behalf or reaching out to anyone on your behalf. Do you understand that, sir?
Yes, ma'am.
All right. All right, thanks, folks. All right, Mr. Shade? Christine Lingard on page 5.
No problem. Morning.
Ms. Lingard, you're before the court this morning. You have a felony violation of probation with a no bond hold for Judge Coleman. And then there's a misdemeanor KPS from the south. And it looks like you didn't show up for court when you were supposed to on May 16th of this year. So I find probable cause. You have court with Judge Coleman tomorrow at 8:30 a.m. on the VOP matter. You have a $50 bond on the KPS matter. Okay?
Okay.
All right. Miss Howard.
Yeah, here's two.
On page 6.
For President Judge May?
All right, so Ms. Howard is before the court on one charge of possession of cocaine. Charge 2 is possession of MDMA. 3 and 4 are misdemeanor capuses. Those are on municipal ordinance violations. I find probable cause. Looks like he didn't show for arraignment on November 4th of this year. All right,
Yeah, those judges, we just asked it to go to the division.
all right, so finding probable cause, I'll leave the standard bonds in place. And you have court with your division judge tomorrow at 9 a.m. All right, John Osvaldo on page 10.
Come on up, sir.
Mr. Osvaldo, you're before the court on 2 misdemeanor cases. You didn't show up for arraignment August 23rd and August 16th. So I find probable cause.
It's a time served offer, Judge.
Mr. Osvaldo, what do you want to do today?
I'd like to, I can pay it on the 3rd. I get paid on the 3rd, my check, and I can pay whatever it is he needs to pay. We need paid on the 3rd.
Oh,
I'm
the,
I'll clear
well,
everything up.
the question, all right, so then the question is, do you want to resolve your case today? Or do you want to pay your bond and then deal with the cases afterwards?
Well, I would like to resolve it, but I would like to ask the court if I could pay it on the 3rd.
Well,
don't
if you have court costs, that's okay. I'll give you 6 months to pay the court costs. So is that,
As far as this here, I do not get paid to the 3rd.
all right, Mr. Osvaldo, I don't know what you're talking about paying, but if you are referring to paying the court costs, I will give you 6 months to pay the court costs.
It's okay, time served, he said.
Right,
To get out.
right.
Okay.
So do you want to do that? Oh, you were thinking about paying the bond?
Well, no, I don't have the money for the bond to the 3rd is what I'm talking about.
All right, so, okay, so we're going around in circles. Do you want to resolve the case and be done with it today?
Yes.
Or do you want to pay your bond?
I guess I want to resolve it.
Okay. All right, so if you want to resolve the case today, then I'll sentence you to time served. You will
Okay.
have court costs, but I will give you 6 months to pay the court costs.
Okay.
All right? And if
Yes,
you,
ma'am.
all right, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, you can put your hand down. And Mr. Osvaldo, do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, Your Honor.
You understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything
It's a thing of the
about,
past.
is there anything about that illness today that would prevent you from making a decision?
No, Your Honor.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, Your Honor.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication, time served. You have 6 months to pay your court costs. Good luck, sir.
Thank you, Your Honor. Have a great day.
You too. Charles Coleman on page 11. All right, Mr. Coleman, you're before the court also on a misdemeanor KPS on a municipal ordinance violation. You didn't show up for arraignment on September 9th. And so, Mr. Coleman, you have an option today. You have a $100 bond that was set by your judge. You can post the bond, or you can resolve your case today.
Resolve.
Okay, sir, it's time served?
Yes, ma'am.
All right, sir, so there's the offer from the city is time served. Do you wish to accept that?
Yeah.
Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And Mr. Coleman, do you understand the offer that has been extended to you?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time? Guilty or no contest?
Guilty.
All right, I accept your guilty plea. I find that it's freely and voluntarily given. And your sentence serves adjudication, time served. Good luck. And then on page 18, Michael Robest.
Mr. Robust has some family here, Judge.
Okay,
Judge, for the municipal ordinance violation, it just asked that it goes to the division.
all right. So Mr. Robest is before the court this morning. Charge 1 is robbery by sudden snatching without a firearm. And then number 2 is a misdemeanor capias on a municipal ordinance violation. That judge issued a $500 bond on that charge. So I find probable cause this morning, and I'll hear from the parties. Good morning.
I just wanted to let you know Mike, he a good person. Like he about to graduate. Like he got 2.5 credits left. Just kind of holding him back. I just wanted to let y'all know he a good person. He's just Mike is a good he good person. He close to me. He means something to me. I just don't want to see him like this. So
Okay. Yes.
This is the 4th time Mr. Robes has been picked up on a robbery. 3 times as a juvenile. 1 strong arm robbery, 2 robberies by sudden snatchings. The 2 robberies by sudden snatchings were non-files, and he pled out the strong arm robbery to a theft and disorderly conduct. I'm going to be requesting a $5,000 bond and no victim contact.
And Judge, Mr. Robes, unfortunately, he's not in a financial position to post the bond. He is going to school. He goes to Whittam Rogers. That's what he advised me. He's a couple credits short for being able to graduate. Now, he's 19 years old, been living here his whole entire life. Lives with his father. He actually gave me the number of his father. I'm going to reach out to him to post a monetary bond. His resources are limited, so I was going to be asking you to consider a $2,000 bond on Mr. Robes' behalf, Judge.
All right, sir, you were raising your hand. Is there something else you wanted to say?
I just want to know I was in juvenile, right? So it's.
Your juvenile record does not leave you behind. It follows you. So, just because it happened when you're a juvenile doesn't mean that it doesn't count towards you when you become an adult. This is why I tell people you've got to make the right decisions, because no matter what you do or when you do it, it does not leave you behind. It follows you. Okay? All right. And so what I heard this morning is that Mr. Robest has been.
If I may, Judge.
Yes.
In speaking with these 2 young gentlemen earlier, they indicated that there is some money available for bond.
Okay.
But they weren't able to give me an exact amount as to how much they might be able to post.
Okay.
So do you guys have any idea how much you might be able to come up with to bond Michael out of jail?
So if the bond set up on 2,000, we could get the money.
Then we would ask for a $2,000 bond, Judge.
These taking phones and all these things have become a thing that everyone just seems to lose their minds over. I don't understand it. All right, so I'm taking into consideration that Mr. Robest has been in contact with the law before, similar nature of charges, and so at this time, I am going to impose a $5,000 bond on one. He has a $500 bond on the KPS that was issued by the judge. He didn't show up for a calendar call on October 31st of this year. All right, he has court tomorrow with the misdemeanor court at 8:30 a.m. and no victim contact.
Excuse me.
Yes.
But with the cases charge, his father had already came and paid the tickets and everything. Like his father came up here to the court already and they paid for that already.
As to the municipal ordinance, KPS, if that's been resolved?
I'll look that up. Well, that's the thing, I don't know when, as far as what tickets are to be paid for, it's a possession of controlled substance. There really wouldn't be any tickets attached to it.
That his father paid for traffic tickets? This is,
Told me that he paid,
this is not a traffic ticket
no,
charge.
I know. This is the charge I just said. I know.
It's a possession of controlled substance is a charge, so you wouldn't have paid a ticket for that.
His parents told me that they paid. Everything is paid. All that is paid.
A request form to recall the warrant was filled out. It was neither from what I can tell, it was neither granted nor denied. A motion to withdraw the capias was set before Judge Evans for December 2nd, I guess, in case he wasn't picked up on the warrant between now and then.
All right, so everything is in place, as I said before, okay? 5,000. All right, on page 8, Julia Preza.
Julia Press is here, Judge at Maine. She's going to require a Spanish interpreter.
I believe
think
our
we have
Spanish
one.
interpreter is here. Very good, that worked out very well.
All right, Madam Interpreter, please raise your right hand. You swear or affirm to interpret from Spanish to English and English to Spanish?
Yes, I swear.
Please state your name for the record.
Sandra Bryan.
Thank you, Ms. Bryant.
You're welcome.
All right, Julio Presa is before the court today.
Julio Presa está delante del tribunal hoy
One charge of domestic battery by strangulation,
por un cargo de violencia doméstica por estrangulación
and I find probable cause.
y encuentro que ha habido causa probable.
All right, State, does Mr. Presa have any priors?
Checking that right now, Your Honor.
¿Tiene antecedentes? Vamos a averiguar ahora mismo.
One moment, Judge. Keep going. Here's DUI, when's that from? DUI out of the state of Georgia in 2012.
Tiene un cargo de manejo bajo los efectos en el estado de Georgia en el 2012.
Based on the level of violence, the state would be requesting a $10,000 bond and no victim contact.
Basado en el nivel de violencia, el estado pide $10,000 de fianza y no puede tener contacto con la víctima.
All right, Mr. Romero?
Señor Romero.
Judge, Mr. Press be able to afford $10,000 bond. He did advise me his only contact with the criminal justice system was in Georgia DUI in 2012.
Sí me lo dijo que él tuvo un contacto con el sistema judicial en Georgia en el 2012.
He's been living in our community since the year 2000. He's 48 years old.
Ha vivido en la comunidad nuestra desde el año 2000, tiene 28 años.
He's a painter, doing that for about 3 months now.
Él es un pintor y ha estado haciendo eso por los últimos 3 meses.
He gets paid approximately $400 per week.
Él cobra aproximadamente $400 semanales.
He will be abiding by the court order as far as no contact. He'll be residing separate and apart from the alleged victim.
Y él va a cumplir con la orden del tribunal, no va a tener contacto con la víctima y vivirá en un lugar separado.
Judge, we're going to be requesting a property order so we can go back one time with law enforcement to retrieve his property.
Vamos a pedir, señora juez, una orden para que él pueda ir acompañado con agentes de la orden pública al lugar para buscar sus cosas personales.
He doesn't really know who's going to be able to help post his monetary bond at this time, Judge.
I'm sorry, can you repeat for the interpreter?
He's not going to know who's going to be able to afford to post his monetary bond at this time nor how much.
En este momento él no va a saber quién podrá prestar el dinero de la fianza.
All right, the bondsman is here, so I think he has some information.
El fiador está presente, creo que tiene información.
Good morning, Your Honor.
Good morning.
I spoke to his cousin Gladys,
Hablé con su prima Gladys.
and she's a housekeeper in Miami.
Ella atiende casas en Miami.
So she already informed me she doesn't have funds to bond him out, but she would try to see.
Ella ya me informó que ella iba a tratar de ayudar con la fianza.
All right. So at this time, I'm going to impose a $5,000 bond.
Así que en estos momentos le voy a imponer una fianza de $5,000.
No victim contact,
No puede tener contacto con la víctima.
and this no contact is in place until it's lifted by a judge.
Y seguirá vigente la orden de no contacto hasta que un juez lo anule.
No victim contact means no phone calls,
No contacto con la víctima quiere decir no puede haber llamadas telefónicas,
no text messages,
no puede enviar mensajes de textos,
no social media contact,
ni puede tener contacto por los medios sociales,
no third-party contact.
ni contacto por medio de una tercera persona.
Do you understand that, sir?
Señor, ¿usted comprende esto? Yes, ma'am.
All right, thank you.
Okay, gracias.
Is there anyone else who needed the Spanish interpreter?
Yes, Judge.
Who's that?
It would be, hold on page 2, Maria Vasquez Leon.
Okay. Maria Vasquez Leon,
María Vázquez León,
you are before the court this morning for one charge of petty theft,
usted está delante del tribunal esta mañana por un cargo de hurto menor.
and I find probable cause.
Encuentro que ha habido causa probable.
Judge, can we see if bond's been paid?
Puedo ver si hay fianza que se ha pagado.
Nope, it's not showing as paid.
No, no muestra que se ha pagado.
I'm going to contact her family. I'm getting the number now, Judge.
Voy a comunicarme con su familia. Estoy consiguiendo ahora mismo el número de teléfono
To explain to them then how to go about posting this Vasquez bond.
para poder explicarle a ellos cuáles son los pasos de tomar para poder prestar la fianza.
All right, $25 bond and no return to Century 21 in Sunrise.
Ok, $25 de fianza y no puedes regresar a Century 21 en Sunrise.
And Judge, there's one more person that I've been advised to speak Spanish, but I believe they advise they have private attorney, Ms. Digna Almaderas Zaldivar.
All right, Ms. Zaldivar, who's your attorney?
Señora Salzovar, ¿quién es su abogado?
Por los momentos no sé el nombre de él.
At this time, I don't know his name.
Oh, well, who hired the attorney?
Entonces, ¿quién contrató al abogado?
Mi hermano.
My brother.
When did he hire the attorney?
¿Y cuándo fue que él contrató el abogado?
Yo esta noche hablé con él y él me dijo que tenía listo el abogado para hoy.
Last night I spoke to him and he said that he had the attorney ready for today.
All right, well, you don't know the name of the attorney, he didn't tell you the name?
Entonces, ¿usted no sabe el nombre del abogado? ¿Él no le dijo a usted el nombre?
No.
No.
All right, well, the only thing I can do at this time is to leave your case till the end of the docket.
Lo único que puedo hacer en este momento es dejar su caso para último en esta lista de las causas.
And we'll see if an attorney shows up on your behalf.
Y vamos a ver si aparece un abogado de parte suya.
Okay.
Okay.
All right. Thank you. All right. Is there anyone else who needed the Spanish interpreter?
Judge, there's one more gentleman.
Okay.
What's your name? Juan what?
He's on page 16, Rivera.
Yeah, okay. Juan Rivera, Judge, on page 16.
All right, Juan Rivera,
Okay, Juan Rivera
you are before the court today.
está delante del tribunal hoy.
Charge 1 is aggravated battery with a deadly weapon.
El primer cargo es violencia con agravantes con un arma mortífera.
Number 2 is a misdemeanor capias.
Y el número 2 es un delito menor con una orden de captura,
This was issued almost a year ago
la cual se emitió hace como un año atrás.
for a petty theft charge.
Fue por un cargo de hurto menor.
I find probable cause.
Encuentro que ha habido causas probables.
And I will hear from the parties.
Una de las partes.
Your Honor, going to be requesting a $10,000 bond.
Estamos pidiendo una fianza de $10,000.
No victim contact.
No puede tener contacto con la víctima.
The detective that wrote the PC does list that the victim suffered serious injury.
El detective anotó que la víctima sufrió lesiones graves.
I have a concern about Mr. Rivera's ties to the community and his future appearance in court.
Tengo preocupaciones con los enlaces del señor Rivera en la comunidad y que si pueda comparecer en futuro al tribunal.
On his NCIC, I'm getting hits out of Rhode Island, Massachusetts, and New York.
La hoja NCIC veo que tiene información de Rhode Island, Massachusetts y Nueva York.
As you can see, he has multiple aliases.
Como usted puede ver, él tiene varios nombres por los cuales se conoce.
And twice last year, he pled out to unlawful use of false name ID. False name or ID. Identification. False name.
Y 2 veces se declaró a tener identificación falsa. Thank you.
All right, Mr. Romero.
Judge, I was going to be asking for the court to consider a $3,000 bond.
Iba a pedir que el tribunal por favor considere $3,000 de fianza.
He's been living in South Florida for the past 2 years.
He estado viviendo en el sur de la Florida por los últimos 2 años.
He's been working for the same construction company for the past year, making about $100 a day.
Ha estado trabajando por una compañía de construcción por el último año, aproximadamente ganándose como $100 al día.
He lives locally here in Fort Lauderdale, where he's been renting a room, paying approximately $400 a month.
Vive localmente aquí en este lugar, en Fort Lauderdale, alquilando un cuarto donde aproximadamente paga $400 al mes.
I was going to ask for a phone order so he can try and contact fellow coworkers to see if they can help post his monetary bond.
Iba a pedir una orden telefónica para que él pueda llamar a sus compañeros de trabajo para ayudarle a prestar la fianza.
All right, based on the nature of the charges before me this morning,
Basado en la naturaleza de los cargos ante mí esta mañana,
the allegations are that Mr. Rivera stabbed someone in their left chest.
las alegaciones que el señor Rivera apuñaló a una persona en la parte izquierda del pecho
And that the alleged victim suffered serious injury.
y que la alegada víctima sufrió graves lesiones.
All right, and I will impose a $10,000 bond on one.
Le voy a imponer una fianza de $10,000 en el número 1.
He has a $500 bond on two,
Tiene $500 de fianza en 2.
and I'm ordering no victim contact,
Y ordenaré no contacto con la víctima.
not by phone,
Ni por teléfono,
not by text,
ni por mensajes de textos,
not by social media,
ni por los medios sociales,
not by a third-party contact.
ni contacto por medio de una tercera persona.
All right, anyone else needs a Spanish interpreter?
Not at this time here.
All right, thank you. All right, on page 15, Fekal Nate.
Mr. Nate, come on up, please. He's approaching, Judge.
Mr. Nate is before the court on charge 1, DUI with a breath level greater than .15. Number 2, DUI, alcohol or drugs. Number 3, DUI with damage to property or person. And number 4, possession of cocaine. I find probable cause for these charges. And I'll hear from the parties.
I just need a moment to run his history if Mr. Romero wants to proceed.
Okay.
I just wanted to know what the state was asking for as far as bond amount, Judge, so I can wait.
Well, yeah, I really don't know until I see everything that's there.
So I go there.
Oh, yes,
How
James.
you doing, Your Honor? I did speak to his sister Lydia, who's going to assist bonding him out. She doesn't have much funds. She's actually at the vet with her pet now that has cancer, so she just informed me that. But she's limited on funds to help bond him out, but she's awaiting me to call her back. I think
Right.
she's like 70-something, 74.
The only issue is this is Mr. Nate's fourth or subsequent DUI.
Yes.
And on this occasion, he blew a .192 and a .197. Plus, there was an accident that was caused, so, and he's in possession of cocaine.
Your Honor, I'm going to be requesting, and for the reasons you stated, it being a fourth, an enhanced breath, and a crash case, I'm going to be requesting a $10,000 bond on count 2. Should he post that bond pre-trial, TAD monitor, no alcohol or intoxicants, random testing, and no driving until further order of the court.
Judge, in speaking to Mr. Nate, I do realize this is his fourth or subsequent offense according to count number 2. But my understanding, speaking to Mr. Nate, it's been about 20 plus years since he had last contact. He's been living in South Florida for over 30 years. He's 59 years old. And as James did inform, the person that he advised me that he was going to try and reach out to was his sister. I was going to ask for a phone order, but I'm glad she already knows he's here. But from what he told me and James confirmed, basically she's limited on funds, and I believe she is retired already, Judge. So I'm asking you to set a reasonable on its behalf.
All right, for charge 2, I am going to impose a $5,000 bond, then the other standard bonds will remain in place. And if Mr. Nate posts his bond, he'll be on a pretrial TAD monitor and order no driving during the pendency of this case.
Not to surrender anything. Okay.
Okay.
All right. Thank you.
All right. All right, Christine Chavez.
North Broward, I believe.
Yeah, and North Broward? Do you have Christina Chavez yet?
I'm sure she's at the main jail, Your Honor.
Oh, oh, well, well, Mr. Romero says she's in transit, so she probably hasn't gotten to you yet.
Okay, I'll call and keep her off.
All right, thank you. Okay, he's gonna check, so. All right, Kazian Clark,
He's approaching Judge here, man. Come on, man.
all right, Ms. Clark is before the court on one charge of touch or strike battery. It's a first-degree misdemeanor. I find probable cause.
Judge, unfortunately, Ms. Clark has really no one to contact to post a bond. My understanding, Judge, right now she's sort of homeless. My understanding is she got into she was living with her mom. My understanding is I don't think she's welcome there right now. But she is working. She works at Forever 21. She just started at the Sawgrass Mall. This is her third week, and she's making approximately $9.50 an hour. She's a graduate of Boyd Anderson class of 2018. She does want to go to college. She is saving up. I believe she had contact with the criminal justice system as a juvenile when she was about over 5 years ago, when she was about 13 or so. But right now, Judge, no one can afford to post her bond. She's asking to be released on pretrial release, Judge.
Honor, my concern, what I think the court should be aware of, as a juvenile, all of her priors involved violence. She was placed on probation 2015 for 2 aggravated batteries on law enforcement officers and resisting with violence. And there were 2 counts of battery that were dropped. One of the conditions of her probation was to go through anger management.
How long ago was that?
It was 2015.
Okay. All right, Ms. Clark, I am going to release you to pretrial supervision, and you need to show up at the pretrial office no later than tomorrow morning. If you don't show up, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. And then no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, but I got a question. Is that okay?
Okay?
My sibling stays at the house, and I would like to see my siblings. So no contact.
Here's what I'm telling you. With the alleged victim, no contact. You cannot be within 500 feet of the victim. Do you understand that?
Yes, ma'am.
All right. If you're found in violation, you'll be back before me, so I am just telling you that whatever you need to do to stay away, that's what you need to do. All right.
Your Honor, could you please recall Ms. Echevis?
Okay. Christine Echeves.
She is in North
Chavez?
Broward, Judge, but she will not be able to attend court this morning.
So you're asking to be reset?
Yes, ma'am.
All right, so we'll reset Christine Chavez.
Thank you, Judge.
All right. Michelle Davis.
All right.
All right, Ms. Davis, you are before the court this morning on one charge of trespassing,
Yes.
and I find probable cause.
I'd like to handle the case today, ma'am. If you don't mind.
What was that?
She wants to resolve the case.
Resolve the case.
State?
All right, the state's offered being adjudication time served, Your Honor. Just so Ms. Davis is aware, she was just arrested for trespass on the 8th and was released on the 12th. If she comes in again in the near future on another trespass, the offer from the state probably will not be time served.
Is it from the same location?
No.
It was,
All right,
yes.
Miss Davis.
Yes.
So at this particular Walmart, the probable cause affidavit says that you have been trespassed from this location since September of this year.
Yes, I was trying to
Oh,
talk to the
ma'am,
manager.
ma'am,
Okay.
stop talking and you've got to listen to me. You've been trespassed from that property. You cannot go back to that property. Do you understand that?
Yes, I understand.
That's what the trespass means. It means at no time you go back there. Do you understand that?
Yes.
All right. So if you understand that, I will help resolve the case today and sentence you to time served. I believe that this has been a medical reset maybe once or twice. So she's
That's
been in
correct.
for about 2 days now. So I will sentence you to time served, and I'm gonna put on the order, no return to Walmart, even though they already have on record a no trespassing order for you. Do you understand that?
Yes.
All right. So if you understand everything and you wish to resolve the case today, I'm going to have to ask you some questions to take a plea. So I'm going to ask you to raise your right hand.
Okay.
Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Please state your name for the record.
Michelle Davis.
All right. Miss Davis, do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No. No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
No, I don't want to go to trial, so no, I'm giving up that right.
Okay. And have you ever been treated for mental or emotional illness?
Yes, I have in the past.
And is there anything about that illness today that would prevent you from making a decision about this case today?
No, just try to get food stamps and stuff.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I do agree. Yeah.
What
Yes.
plea?
So I'm a citizen. Yeah.
Okay, what plea do you wish to enter at this time? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, Ms. Davis, is adjudication time served. I'll give you 6 months to pay your court costs. Good luck.
Okay, thank you.
Nisha Jacroy.
She's here at Main Judge.
All right, Ms. Jacroy is before the court this morning. Charge 1 is grand theft auto. Number 2 is resisting officer without violence. I find probable cause for these charges.
Judge, Ms. Jacoy advised me she's not gonna be able to post her bond, and she knows nobody that's gonna be able to post her bond. She's homeless, she's 9 years old, been here her whole life. Right now, she's working for a landscaping company. She's been doing that for the past month, where they pay her about $40 a day. She has prior contact with the criminal justice system, but I'm asking on these nonviolent offenses if the court would consider releasing her on pretrial release.
All right, state.
Your Honor, if the court is inclined to place Ms. Jacoy on pretrial, I would just ask if you could advise her that it's her responsibility to either contact her attorney or pretrial or the clerk for future court dates. Since the clerk is apparently not going to be able to get notice to her.
Well, I am not inclined to placing Mr. Croy in pretrial. The allegations are that her and, I believe there's a co-arrestee on the docket today, stole a vehicle. Once they realized that they were being followed by officers, they jumped out of the car, crashed the car into a tree, and then they went hiding. Officers had to use canine to locate both of them. And so at this time, I am going to leave the bonds in place. She has a $1,000 bond on one and a $100 bond on two. Carissa Young.
No problem.
Ms. Young is before the court this morning. Charge 1 is battery on an officer or firefighter. Number 2, false ID given to law enforcement. Number 3, disorderly conduct. And I find probable cause.
Your Honor, I'm going to ask the court to consider pretrial release for Ms. Young. From what she advises me, she has no prior record whatsoever. She's been living in the same location for the last 8 years. She lives with her mother. Her grandmother was also living there. Unfortunately, her grandmother passed away recently. She does have a job in the vacation industry, arranging people's vacations. She works 6 days a week, and she's had that job for about 2 months. She has 3 years of college, some of that at the University of Texas and and she's currently attending Jarvis University?
Christian College.
Jarvis Christian College. So considering her lack of a prior record, ties to the community, employment, seeking a higher education, I'd ask the court to consider a pretrial release. I don't know that there's any money out there for her to post a monetary bond at this time.
Just reading these allegations and hearing what Mr. Reedy is telling us, it just doesn't seem to go hand in hand. Guys, please. It doesn't seem to go hand in hand with what's described here. I'm checking to see if there's any history. I can tell you, despite being 21, well, actually, let me check this. Your Honor, if the court is inclined to place her on pretrial, I'd be requesting a psychosocial evaluation be done. And any follow-up treatment. Hold on a second.
If that's what it would take to get her on pretrial release, we would agree with that, Judge.
All right, because I have to agree that these facts don't seem to make any sense.
Yeah, I don't know exactly what happened, but, I don't have any real reason to doubt what Ms. Young tells me about her current status. But yes, I agree that this behavior is, of concern.
All right, I'll ROR to pretrial supervision, and I'll also order a psychosocial evaluation with any follow-up that is required. All right, so Ms. Young, I am placing you on pretrial supervision that's in lieu of posting a monetary bond. But here's what is going to be required of you. By tomorrow morning, you need to go to the pretrial office to sign up.
Came through the other day.
If you don't sign up at the pretrial office, a warrant will be issued for your arrest. Do you understand that?
How do I get there?
You were just given that
It was on the PM document.
information with the address. It's right across the street from the courthouse in downtown Fort Lauderdale. So that's the address, and you have to, that's where you have to show up. Also, I am ordering a psychosocial evaluation, so you must cooperate with the pretrial office to get that done. Do you understand that? All right? Okay.
Good luck, Carissa.
Thank you so much. Thank you so much.
You're welcome.
Thank you so much. I'll take this. Okay.
All right. right, good morning to the students.
So, but he wouldn't be coming through anyways. We wouldn't call him if he's just
Okay, I was wondering if there was a delayed response there.
Scott.
I was gonna say, didn't you give these guys any breakfast this morning? All right. All right, so you need to pay attention because there is going to be a little quiz. I'm just kidding. You should see the looks that I got. But pay attention, and if you have any questions, I'll take some time to answer any questions that you have. So either write them down or think about them, right? All right. Antoinette Roberts.
Ms. Roberts is here.
See? No, we don't.
All right.
do
And Ms. Meredith, can I ask you what time is your expected departure? So I,
It'll probably be,
okay, all right.
that's
All right, Ms. Roberts, you are before the court this morning for charge 1, burglary, unoccupied conveyance, unarmed. And number 2 is petty theft. It's actually a felony petty theft. So it's your second, it's third or subsequent offense, so it's now a felony charge. So it's a felony petty theft. And I find probable cause for these charges. And I know it is usual that this is from an incident that occurred July of this year at the Comfort Suites in Dania Beach. All right. State, does Ms. Roberts have any priors?
Yes, well, Your Honor, she just was arrested, looks like on the 27th of last month for leaving the scene of an accident with injury and felony DWS. She posted a $2,750 worth of bond and was released. DWS habitual offenders in 2015. 09, 2 counts of attempted burglary of a dwelling, grand theft, and petty theft. She was sentenced to probation as a habitual offender. Grand theft, 2010. Grand theft, criminal use of personal identification information, 06. 26 and a half months state prison. Aggravated assault and battery, 02. VOP, same sentence. Theft, 03. Grand theft and uttering a forged instrument, 98. Grand theft, forgery, uttering a forged instrument, 3 counts of unauthorized use of a driver's license or ID, 97. Based on the totality of the circumstances, state would be requesting a $5,000 bond on the burglary.
Okay.
Judge, in speaking with Ms. Roberts, we're going to be asking the court to consider a $1,000 bond on count 1. I do understand Ms. Roberts has a history with the criminal justice system. My understanding, as you heard, this date of incident was back in July. Having said that, unfortunately, Ms. Roberts, her oldest daughter passed away this week. She was 22 years old. She was actually driving back from making funeral arrangements. She's living right now with her other daughter and her grandchildren. Her other daughter is a hairstylist. Right now, most of the family's income is going towards funeral expenses. She is not working. She's 45, been here her whole life. But I'm asking Judge so that this family can be in a financial position to post Ms. Roberts' bond so she could be there for the actual funeral of her daughter. I'm asking the court to consider setting a $1,000 bond on count 1.
It is unfortunate what's going on with Ms. Roberts, and I express my condolences. But we have a charge here that we have to deal with, and
I was actually in the middle of preparing for the services and things.
that's,
Everything's on hold now with the funeral because of my position.
well, I understand that, but this is not your first time with law enforcement. And And I understand. So I am going to impose a $2,000 bond on number one. You have a $750 bond on two at this time. All right, Latoya Smith.
Ms. Smith is approaching Judge. She's here, man. Come on up.
Ms. Smith is before the court this morning on charge of operating without a valid driver's license. Number two, false ID given to law enforcement. Number three, out-of-county misdemeanor hold. That is out of Miami-Dade. Number four, out-of-county felony hold. That is a no bond hold, also from Miami-Dade. Number five is a misdemeanor capias. And I find probable cause for these charges.
Judge, in reference to the Broward misdemeanor offenses, specifically counts 1, 2, and 5, and speaking with Smith, she's wanting to know if the state had a plea offer in order to resolve those offenses.
One moment. No, count 5 is a capias from failing to appear at a violation of probation.
I did see that it's a VOP hearing that she failed to appear. So she has court tomorrow scheduled before her division judge at 8:30. And so finding probable cause, I am going to leave all the other bonds in place. Okay. Tiffany Burns.
She's approaching, Judge. She's here, man. Come on up, man.
All right, Ms. Burns, you're before the court on charge one is possession of cocaine. Number two is possession of THC, and I find probable cause for those charges.
Judge, my understanding is Ms. Burns, from what she had advised me, this is her first arrest. She's 25 years old. She is working here. She works at True Food Kitchen, which is located in Boca, as a server. She's been there for 3 months. She makes about $5 plus tip. She lives in Boca Raton, where she rents an apartment with 2 roommates, where she's been living for 1 year. Her share is about $600 a month. I'm asking if the state can confirm she has no prior contact. I'm asking for, on these nonviolent offenses, to consider releasing Ms. Burns on straight RWAR. If the court's not comfortable, then we would ask for the court to consider a pretrial release for Ms. Burns.
Also checking to see if her bonds have been posted. Yes.
Has been posted? All right, so Ms. Burns's bond has been posted. Do we have Joan Marie Marsaro today? Yes. Mr. Romero, can you bring Ms. Burns back?
Oh, Ms. Burns, come on.
All right, so her bond has not been posted. Apparently she tried to self-bond and it didn't work. So.
That's what I believe. That's what I thought. She thought maybe somehow somebody managed to
Okay.
bond her out, but.
I don't have an objection to pretrial to random testing. The only thing I'd bring up, I notice the booking has a Massachusetts address. I just want to make sure, for all I know, the clerk may end up using that address for notice, so she could just be advised what steps she has to take to update the clerk.
All right, so Ms. Burns, the first thing is that you need to, what is your current address?
let me know as far as the book goes.
What's your,
current address in Boca is 8237 Drive. I just put my
okay,
mom's
hold
address
on.
here.
Just tell me the address. 82 what?
30
Yes.
Severn Drive,
How do you,
Severn
okay,
Drive,
okay.
Boca Raton,
What's the zip code?
33433.
Is there an apartment up? 'Cause I see a- oh, sorry.
33433,
Yes, ma'am, apartment C.
apartment C.
Yeah, it's on the
Yes, ma'am.
PC affidavit.
All right. All right, so I am going to release you to, on your own recognizance, to pretrial supervision. The attorney's giving you the information for the pretrial office, and you have 24 hours from the time that you're released to report to the pretrial office. If you don't report, a warrant will be issued for your arrest, and you'll be probably before me again if you don't show up. Do you understand that?
Yes, ma'am.
Also, as part of your pretrial supervision, you will be subjected to random drug testing. And I'm asking pretrial to test once per week, at least. Okay? All right? So you need to show up by tomorrow morning. All right, did we have Joan Marie Marsaro today? Is she still on medical loan or is refusing?
As far as I know, Judge, yes.
Still medical reset, okay?
Yes.
And how about Ebony McLemore?
Medical reset also.
Medical reset as well?
Your Honor,
Yes.
I would just ask if the court would be inclined to make a probable cause determination. She was arrested on the 15th.
On who, Miss McLemore?
Yes.
We didn't do the, can I
I
see the?
don't think it's.
I don't know if, I know we did the other one. Oh, no, this was from the weekend. All right, so on Miss McLemore, I'm making a finding of probable cause for attempted burglary, occupied dwelling unarmed, and number 2 is resisting officer without violence. She has to be reset for bond purposes. All right, let's take a brief recess, and then we'll be back. Record? Yes. Oh, you didn't check if they had him? You didn't check if they had him?
He's there.
He is?
Yeah, because they told me that Mr. Gottlieb and Mr. Strandell were representing him.
Okay, so, okay. Ethan Guinazzo,
So at the very end.
all right, Mr. Guinazzo, this is a change of charge. And the KPS says, because now I'm learning to read from the KPS, it's murder in the second degree with a firearm. And he had a bond before, or
Your
what
Honor,
were the
there was no-
conditions before?
There was no bond before, there's no bond now, at this point, it's just a formality.
Okay,
And Mr. Guinaz is actually scheduled for arraignment before Judge Weeks tomorrow morning.
okay. All right, so we'll leave the no bond.
Yeah, Judge Davis made a preliminary finding of proof evident presumption grade. I just asked the court to adopt that finding.
Okay. All right, so we will leave that in place, proof evident presumption great without prejudice for him to have a bond hearing. And until such time, he'll continue to be held no bond.
Thank you much.
Okay, you're welcome. All right, Mike Ortiz.
It's a question, Judge, here, man. Come on up, sir.
All right, Mr. Ortiz is before the court this morning. Charge one is sexual battery. The victim 18 years or older by a person 18 years or older. The charge number two is aggravated battery with a deadly weapon, dating violence. And number three is aggravated assault with a deadly weapon, dating violence. I find probable cause for these charges.
Your Honor, the state, well, first I'll go with the bond amounts I'll be seeking. I'm requesting a bond amount on count one in the amount of $250,000, $100,000 on count two, $50,000 on count three. No victim contact should he post bonds, pretrial release with a GPS monitor level 1, no firearms, weapons, or ammunition. Your Honor, I won't go into the details as the court is familiar with the allegations, but it goes without saying. First, frankly, in my professional opinion, I think the arresting officer would have been justified to charge him with attempted murder in the first degree based on what's alleged in this report. These allegations are of such a heinous and alarming nature, it is impossible not to have great concern for not just the victim's safety, but her life. Your Honor, I would also note what is also cause for concern. Mr. Ortiz is out on bond right now for battery on a law enforcement officer, domestic violence battery. The alleged victim in that case is his mother, who was present at the scene, who tried to stop him from attacking the victim, but she was even unsuccessful, and resisting without violence. Your Honor, it's up to the court to respond, but I do believe it would be appropriate to revoke his bond in that matter, considering the allegations in this case, and that is also a 2019 case. Additionally, Mr. Ortiz was arrested twice in 2018 for battery against the same alleged victim and violating pretrial release conditions, that being the no victim contact order in that case. In each case, the charges were dropped. So he has shown in the past that he is unwilling to follow release conditions set by a court. He additionally has a resisting without violence in 2016 and DUI property damage in 2012.
What is the case number that he's out on bond on?
199659 CF10A.
Mr. Romero.
Judge, and speaking of Mr. Ortiz, he's looking forward to fighting these allegations. Having said that, Judge, $350,000 on counts 1 and 2, which the state has asked for, that's something that Mr. Ortiz is not going to be able to afford. He advised me he owns no sort of property. He's been here for 10 years in South Florida. He's 41 years old. He is working, Judge. He's just got a job. He's been there for about 3 months working at Starboard Marine Yacht, where he fixes boats. He makes only $13.50 an hour, Judge, but he's basically financially indigent. I'm asking you to take that into consideration, determining reasonable release conditions for Mr. Ortiz.
All right. We have Mr. Ortiz, who's out on bond on case number 199659 CF10A, and that is a domestic violence matter as well.
There's one charge of domestic violence battery and one charge of battery on a law enforcement officer.
All right, and on that case, at this time, I am going to revoke his bond and hold him no bond on that case. With a pending domestic violence matter, Mr. Ortiz is before the court on another 6 bat and an aggravated battery and an aggravated assault. There's allegations of sodomizing the victim with a broomstick and then using a knife to assault the victim. And based on these allegations that he put a pillow over her face, attempted to suffocate her, telling her that he was going to kill her on 2 occasions. So based on these allegations of violence at this time, I am going to impose a $250,000 bond on charge number 1, $100,000 on 2 and 3, no victim contact. And sir, that means no phone calls, no text messages, no social media, no third-party contact. And if you're able to post your bond or you're released on the other matter at some later time, there will be a 500 feet stay-away order from the alleged victim. Okay? I said 250 on 1, 100 on 2, 100 on 3, 100,000. Okay. All right. John York.
No problem.
All right, Mr. York is before the court. Charge 1 is domestic battery by strangulation. Number 2 is battery causing bodily harm, domestic violence. Number 3 is tampering in a 3rd-degree felony proceeding. And I find probable cause for these charges.
The state would be requesting a $7,500 bond on 1, $2,500 bond on 2 and 3, no victim contact. I know he has no local priors. I am not aware if he has priors outside of Broward.
Okay.
Judge, Mr. York advises me he's been living in South Florida for 35 years. He's been living at the same location for the last 6 months. He lives by himself. He's not currently working, unfortunately. He does have some college. He has had some contact with the criminal justice system in the past. He understands he has to make arrangements to live or not to have contact with his mother. And he has no money whatsoever, Judge, to post a monetary bond and doesn't know anyone who's going to be able to bond him out. So I'm going to ask the court for pretrial release with whatever conditions this court thinks are appropriate.
All right. I am going to not deny the pretrial release. He'll have a $5,000 bond on charge 1, $2,500 on 2 and 3. No victim contact. Sir, that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes.
Okay.
Judge, I say something? Judge.
Don't discuss the facts of the case, Mr. York.
What I'm saying is that if you give me no bond, if you telling me I don't have no bond and I don't have no money, then I must stay here. So if you give me bond, if you give me a bond, if you let me free on my pornography and I get to go free, and I have a mental illness. Why can't I go into a program if I'm homeless and then get rehabilitated in this area, in another area?
Well, then, that's something that you need to discuss with your attorney. At this time, you have a total of a $10,000 bond, okay?
Okay.
Michael Downey. Mr. Downey is before the court on one charge of petty theft, and I find probable cause.
Judge, Mr. Downey wishes to resolve this matter today.
All right.
The offer from the state would be adjudication, 3 days county jail based on the allegations in the report. And no return.
He has priors.
Yes. Had a trespass end of October, in April, resisting without violence, some type of municipal ordinance, and an unlawful use of false name ID. March of last year, false ID, resisting without violence, and trespass. Do you have them in there?
So the most recent was October.
Late October, yes, Judge.
Judge, and I just spoke with Mr. Downey. I believe this was at a Walgreens in which the alleged item was deodorant. He believes that this may be his first petty theft. If that's correct, would the court consider, I would invite the court into plea negotiations to consider potentially extending a withhold.
One, Your Honor, I would also note that according to the store manager, Mr. Downey has stolen from the store multiple times in the last couple weeks. One moment, I've got to check his history. Well, he was convicted in the state of New Jersey in 2012 and placed on 2 years probation for unlawful taking means of conveyance. Sounds like either grand theft auto or burglary of conveyance.
There is allegations he's stolen from the store numerous times, one. And the other thing is he does have a theft out, not in Florida, but somewhere else. So I think that the 3 days is reasonable at this time.
He wishes to accept the state's offer, Judge.
All right, Mr. Downey, please raise your right hand. Do you swear or affirm to tell the truth?
Yeah.
Okay, you can put your hand down. Do you understand everything that we've discussed here today?
Yeah.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yeah.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yeah.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that is freely and voluntarily given. Your sentence, sir, is adjudication, 3 days in the Broward County Jail, credit for any time served, no return to Walgreens. Christopher Murphy.
Come on up, Mr. Murphy.
Mr. Murphy is before the court on a misdemeanor capias. You did not show up for arraignment on September 19th of this year. The charge is suspended driver's license, first offense. I find probable cause. Mr. Murphy has court before his division judge tomorrow at 9 a.m.
Judge, Mr. Murphy advised me he wishes to resolve this case. However, he also did advise me, when was the alleged date of incident on this driving while license suspended?
That was in March, the same time that the original charge. They just split, there were two charges. They split it off for some reason. I don't know. I guess one was traffic, one was something else as well.
March 12th.
March 12th.
Does he have priors? Because the judge issued a $5,000 bond on the KPS.
That was the one, because I missed the court, it was Judge Solomon, and I didn't make it to the court date.
Which is unusual for such a high bond on a KPS.
It's because it's the second time he failed to appear in
It's
this
the
case.
second time he failed to appear. Okay. Well, I'm not gonna accept any plea offers. He has a $5,000 bond, and he's also scheduled to see Judge Solomon then tomorrow at 9 a.m. John Maurice.
Mr. Maurice is approaching, Judge.
Good morning, Your Honor.
Good morning, Mr. Maurice, you're before the court. Charge 1 is criminal mischief. Number 2 is a civil writ with a purge amount of $1,084. That's not for magistrate. I find probable cause.
Judge, considering the purge amount of $1,084, nothing to add at this time.
Your Honor, I would just ask for an order of no return to 4919 Whispering Way in Dania Beach.
I don't understand what this is about, throwing screws in the path of incoming and outgoing vehicles. I guess the victims that they were able to find, there's already a total damage amount of $846.44. More vehicles were damaged, but the victims were not at home, and so they haven't yet been able to determine the dollar amount of the damages. On the criminal mischief, I am going to increase Mr. Maurice's bond to $1,000. And he has another $1,000 on the writ. And no return to this Whispering Palms community. Alvin Brazil.
Mr. Brazil, come on up, please.
Mr. Brazil is before the court on a trespassing charge, and I find probable cause.
Judge, Mr. Brazil wishes to resolve this matter today.
Okay.
Offer be time served, no return, Judge.
All right, Mr. Brazil. So I want you to understand that if I take this plea offer, there is a no return to Linus Food Market at 3951 Northwest 7th Street in Plantation. Do you understand that?
Yes.
All right. So if you understand that and you're willing to comply with that, I will accept a plea offer and sentence you to adjudication and time served. Do you wish to accept that?
Yes, ma'am.
All right, sir, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And Mr. Brazil, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with the attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck. Norman Vaughn.
Bonded.
Mr. Vaughn bonded. This was on a capias. Daniel Cavalan Conti.
Bonded.
Is bonded, and I find probable cause. Keon Leba.
Mr. Lager, come on up, please.
Mr. Leba is before the court. Charge 1 is selling alprazolam. Number 2, possession of alprazolam. Number 3, distribute or deliver cannabis. Number 4, possession of cannabis over 20 grams. Number 5, possession of drug paraphernalia. Number 6, possession of open container. And number 7 is a felony violation of probation. This is before Judge Siegel, and it's a no bond hold. And you will see Judge Siegel tomorrow at 8:30 a.m. I find a probable cause. And I will leave the bonds in place. Anthony Carter.
Approaching, Judge.
Mr. Carter is before the court. Charge 1 is grand theft auto. Number 2 is resisting officer without violence, and I find probable cause.
Judge, nothing to add at this. I'm going to be contacting Mr. Carter's fiance to post his bond.
All right, and Mr. Carter has a $1,000 bond. All right, Javaris Fleming.
Mr. Fleming, please approach the judge. He advises he has private counsel. Mr. George Odom, I believe my colleague contacted him.
I did leave a message for Mr. Odom. I have not heard back.
Okay.
Give him another try right now.
All right, so, Mr. Fleming, we're trying to reach your attorney. We'll recall your case if we hear from him, okay?
All right.
Marquise Marrero.
Mr. Marrero, come on up, please. One moment, Judge.
You reset who?
Marrero, 17.
All right, Mr. Marrero is reset to the PM because they have an additional charge that they need to add. So this has been reset. Nicholas Bryce.
Bonded, Judge.
Mr. Bryce bonded. I find probable cause. Demosthenes Polos.
He's here present, Judge. Your name?
All right, Mr. Polos is before the court. Charge 1 is falsely identifying self as a contractor. Number 2 is grand theft, $5,000 or more, but less than $10,000. I find probable cause. Any priors? Does Mr. Polos have any priors?
Sorry, Your Honor.
Judge, nothing to add from the defense. I'm going to be contacting Mr. Paul's friend to post his bond.
It looks like he was extradited here from Nevada as well. And I'm showing he's on supervision, misdemeanor probation in Nevada as well.
All right, I am going to increase the bond on number 2 to $5,000. And no victim contact. All right.
It's just on the warrant.
Corey Bailey.
He's a medical reset, Your Honor.
Mr. Bailey's medical reset. Purnell shingles.
One moment, Judge.
Okay.
He's approaching, Judge.
So Shingles is before the court on one charge of grand theft, and number two is resisting officer without violence, and I find probable cause.
Judge, Mr. Shingles is requesting if the court would consider releasing him ROR. Straight ROR.
Okay, does, Mr. Shingles have any priors?
Pled out a resisting without violence in September of this year. Last year, possession of controlled substance. On March 5th of this year, he was sentenced to 270 days. Last year, possession of substituted cathinones, he received the same sentence. Battery, 2018. 2015, criminal use of personal identification information, just over 26 and a half months state prison. 2013, burglary of a dwelling, same sentence. Theft, 2014. Delivery of cocaine, 09. Nothing further.
This time I am going to deny the ROR. He has a $1,000 bond. Sean Hunt,
Mr. Hunt, come on up, please. How you doing, young?
all right, good morning, Mr. Hunt. You're before the court this morning. One charge, charge one is trespassing, occupied structure or conveyance. And then 2, 3, and 4 are felony violation of probations. Those are before, it says Judge Bailey, and so you will be before your division judge tomorrow at 8:30 on the VOP matters. I find probable cause, you have $100 on bond on charge number 1, okay? Anthony Haney, do we have him today?
Yes, ma'am, no problem, John.
Mr. Haney, you're before the court on one charge of possession of cocaine.
Yes, ma'am.
And I find probable cause for that charge. Does anyone wish to be heard on Mr. Haney's case?
Yeah, Judge, Mr. Haney's been living here about 7 years. He's been living in the same location for the last 7 years with his dad. He doesn't know if his dad's gonna be able to bond him out. He has a job working maintenance, which he's been doing for some time. He does not have financial wherewithal to post bond. I can tell you this is not his first contact with the criminal justice system. But he does not believe he's going to be able to come up with $1,000 bond. I'd ask the court to consider a pretrial release, or in the alternative, reduce the bond.
Based on the allegations in the probable cause affidavit and the concerns, the similar concerns that the officer expressed in the affidavit, I am going to leave the bond at $1,000 at this time.
Your Honor, just for record purposes.
Yes.
Mr. Haney was actually arrested June of this year on a violation of pretrial warrant for his last felony case from 2018.
All right. And Mr. Haney, no victim contact, sir. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yeah, who's the victim?
All the more reason why I don't know what the medical reset was from yesterday, but you'll speak with your attorney in regards to all of that, okay? All right, Isaiah Calhoun. All right, so this is a change of charge. There's a change of charge KPS for Mr. Calhoun. It says attempted murder in the first degree.
Your Honor, Judge Davis, at his original first appearance, found proof evident or presumption grade for attempt. He wrote an attempt on the findings.
So this was just a technical, it didn't, okay?
Yes, ma'am.
And it's still, the determination still doesn't say attempted. All right, so this is already a previous finding from Judge Davis. So we'll leave that in place, that there's a proof evident presumption grade without prejudice for him to have a bond hearing until such time he is being held no bond. Okay, Hector Chevalier, he's in court.
Your Honor may
Yes.
recall,
Yes.
Mr. Chevalier before you last Friday in a motion of release,
Yes,
where we filed any information. It was a technical change of charge. I'd advise the court, and Mr. Chevalier discuss this with you. Judge Garcia Wood already reduced his bond on this matter to pretrial with a GPS open schedule. Unless Mr. Reedy has an objection, I'd ask that the court just place that,
so just for this the keep is charged burglary? Is that the charge?
yeah, what happened was, I have no objection to an ROR in the theft.
I don't even have.
Yeah, it
theft.
should be there, but it's not.
Well, it's on the KPS.
Yeah, no, it's on the KPS, it should be in the findings.
All right.
Since Judge Garcia Wood ordered the rest of the bond, I think it'd be appropriate just to put that.
So he was, Judge Garcia would ROR'd him to pretrial?
Yeah, I'll bring up the order, I just want to make sure Mr. Reedy.
Okay. Oh, you wrote for order.
Yeah, full hearing.
Oh. Oh, with a GPS, so it's level 2 open schedule.
Yeah, it should be on the total case, both charges.
And then on the petty theft charge, will ROR. So level 2,
It's actually, it's not level 2, it's open schedule.
she says with a GPS. It says pretrial release with a GPS.
Yeah, it says open, but level 2 is an open schedule, is it? Oh, I always thought it was level 1, level 2, and then, okay, my bad.
Okay,
I thought open schedule was separated from level 2.
all right, so then we don't need to bring Mr. Chevalier back, deputy. It's, or wherever he is, okay?
Okay,
So
thank you, ma'am.
it's ROR to plea trial, okay? All right, thank you. And then Ronkevis Williams,
No problem.
all right, so for Mr. Williams, this is a change of charge as well? Is this just a technical thing, or is it actually a change? Attempted robbery, no weapon.
Sheila, do you know what the bond was originally set at? I don't have the original findings in Odyssey. Wait, one moment, Your Honor. No, it was, not this count. This count was $2,500 you found for attempt. We're here on the strong arm robbery change of charge, not the
So-
robbery firearm.
Attempted robbery, so he had a $2,500 bond?
That's what was set originally.
So we'll leave that in place, okay? And there's only one, okay, all right, so you have it's a change of charge, Mr. Williams, to attempted robbery instead of robbery, and the bond is $2,500, it'll remain in place, okay? All right, so we only have two cases left on the docket, so let's address Javaris Fleming at this time. All right, Mr. Fleming is the gentleman who said he has Mr. Odom as his attorney?
Judge, I spoke with Mr. Odom. He has not been retained on this charge as of yet. He does represent Mr. Fleming on some other charges. He is going to be meeting with the family or reaching out to them this afternoon to see if they are going to retain him on this new arrest.
All right, so Mr. Fleming, you may not have been in the room. I don't know if you heard me when I spoke in the beginning, but just because an attorney is representing you on a pending matter does not automatically mean they're representing you on a new arrest, which is exactly what Mr. Odom is saying. He is going to be meeting with your family to make that determination. So as of this point, you don't have a private attorney. I don't know if you want to continue using the public defender's office or if you want to represent yourself.
Public defender.
Okay? All right, so this is on an arrest warrant. The charge is robbery by sudden snatching without a firearm. This is an incident that occurred on October 19th of this year, and I find probable cause.
Requesting a $7,500 bond and no victim contact. Based on the allegations in this case, and also that Mr. Fleming is actually out right now on two separate felony cases. One for fleeing and eluding law enforcement, the other for carrying concealed firearm and resisting without violence.
All right.
Judge, Mr. Fleming, he's 24 years old, been here his whole life. He is working. He works at a tire warehouse, making only $14 an hour. The only person he said he's going to be able to reach out to help us monetary bond is his grandmother, who gets Social Security. At most, she's going to be able to afford $2,000 using the services of bondman, so that's what we're requesting at this time.
All right, this time I am going to impose a $10,000 bond. All right. And then we have Digna Zaldivar, and I know that Ms. Zaldivar needed a Spanish interpreter.
Yes, Judge, and as far as my colleague went ahead and found out who her private attorney is, and I believe Mr. Reed had a conversation with him.
Yes, I did, and he is going to be representing her, but he has not yet been retained. But he is going to be he's asking everything to be left in place.
Well, and Your Honor, and I really, I'm not comfortable commenting because she needs.
Here's the problem. She asked for a Spanish interpreter, and she thought he was coming, but he's not here. So let's reset this for the PM so
Okay.
that we have a Spanish interpreter.
I'll get one.
And then we'll be able to address it so she understands what's going on. Okay? All right, so that brings us to the end of our morning docket, and I will see everyone this afternoon.